Hi, I'm Sara, your AI-powered compliance assistant. Today, I want to talk about ongoing fee arrangements. As part of the Delivering Better Financial Outcomes package, the Albanese government has made changes to your obligations when entering or renewing ongoing fee arrangements with your clients. An ongoing fee arrangement exists where the financial advisor gives personal advice to a retail client. The financial advisor and client enter into an arrangement, and, under the terms of the arrangement, the client must pay a fee for a period of more than 12 months. It is important to note that an ongoing fee does not exist merely because it has been disclosed in an SOA. It must be entered into through a formal ongoing fee agreement. Say goodbye to FDS and hello to consent. Under the DBFO Act reforms, you no longer need to send your client a fee disclosure statement. These obligations have been replaced with new consent requirements relating to entering into an OFA and paying fees. When entering into an ongoing agreement, there are two consent forms you need to obtain from your client. Firstly, you will need to obtain a signed consent to enter into an ongoing agreement. This is called OFA consent, and is similar to the existing ongoing fee agreement, which outlines the services to be provided and fee payable. Secondly, you will need to obtain a signed fee deduction consent, which gives the third-party product provider a consent to deduct the fee from the client's super or investment account. Let's talk about consent obligations. Consent obligations include a requirement for fee recipients to obtain written consent from a client, to enter into or renew an ongoing fee arrangement, and for the ongoing fees that the client will be required to pay under the arrangement. Written consent must be obtained before you can deduct, arrange to deduct, or accept payment of ongoing fees from a client's account, unless the account is linked to a credit card or is a basic deposit product. A financial advisor must not arrange a fee deduction from a third-party platform without providing a copy of the signed consent. The minister has the power to approve a form for arranging to deduct ongoing fees from an account. However, no form has currently been approved by the minister. Written consent to enter into or renew an ongoing fee arrangement, or to arrange the deduction of ongoing fees from a client's account, can be gained electronically. Your client can sign the written consent electronically by, for example, clicking a checkbox on a web page, sending you their written consent by email with their electronic signature attached. However, a client cannot give consent verbally, e.g., a voice recording or verbal confirmation. This is because the law requires written consent to both enter an agreement and deduct the fee. With that said, the third-party platforms may set their own requirements for client signatures. Anniversary Day is being replaced with a new term called Reference Day. At the time an ongoing fee arrangement is first entered into or renewed, clients and the advisor may agree on a day, known as the Reference Day. Reference Day is used to determine the time frame in which the advisor can obtain written consent to renew an ongoing fee arrangement from their clients. The time frame commences 60 days before the Reference Day and ends 150 days after the Reference Day. Reference Day must be a day that is earlier than the anniversary of the day that the ongoing fee arrangement was entered into. Let's go through an example. On the 1st of February 2025, Billy enters into an ongoing fee arrangement with his advisor, Lisa. Billy and Lisa can agree on a reference day, which must be before the anniversary of the agreement. If a reference day is not disclosed, the time frame is based on the anniversary of the arrangement. The earliest date that Billy can renew his consent to the arrangement is 60 days before Reference Day. In this case, after the 3rd of December 2025. The latest date that Billy can renew his consent is 150 days after 1st February 2026. In this scenario, the 1st of July 2026. If a new consent is not signed before the end of expiry period, the ongoing fee arrangement will terminate. In future, Billy and Lisa can agree on a new reference day, as long as it is before the next anniversary. If you have an existing ongoing fee arrangement with your clients, the new consent obligations will apply at the anniversary of your existing agreement. Consent must be obtained from the client in the period starting 60 days before the existing anniversary day and ending 150 days after the anniversary. Where an existing ongoing arrangement has an anniversary before 10th of January 2025, you will still need to provide your client with an FDS and renewal under the current legislation. Thank you for watching this episode on the changes to ongoing fee arrangements. We will be updating our policies and procedures to reflect these changes. We will also be releasing updated ongoing fee agreements and consent form templates for the X-Plan wizards. See you soon!